This is,
I can't believe it. There's too much going on this morning.
Yo, turn the beat up in Vaughn's dictionary. We ain't spelling right tonight. Nah, we spelling
our
wrong.
clerk to make sure that she's aware we're on the bench and ready to proceed.
Step in the courtroom. Words all twisted. Sheriff Vaughn
Where's my
speaking.
witness?
He was here behind you earlier. He must be in the hallway.
Can I have a second to speak to my witness, please?
Pardon?
May I have a second to brief my witness, please?
No.
Or may I ask that her witnesses be excused too?
May you ask that what?
That her witnesses be excused too?
So you're requesting for the rule? Rule has been requested, Ms. General Bryson. Do you have any witnesses other than the officer?
Judge, the officer is here as the state's representative. The lady seated beside me is not a witness. She's the intern for our office.
Right. The officer is excused from the rule because he is the designated representative of law enforcement, and under the rule, he is allowed to remain in the courtroom. And the other individual seated at the table is not a part of this case, but rather is an intern from Creekwood High School who is sitting in as a part of her education. So now, you have raised the issue. We have a jury waiting downstairs, and you have raised the issue of the fact that there were motions that had not been heard in your case, plus you filed a number of additional motions that you have raised as of today. And I'll deal with those new motions in just a moment if they apply to this case. But the motion that you had addressed earlier was the motion to suppress that had not been addressed. So I'm going to hear that motion to suppress that you are arguing in this particular case. I would remind you, the case that's for trial today is the indictment charging you with simple assault, with false imprisonment, disorderly conduct, and public intoxication.
Oh my God, we've
Those
got a
are the
trial today?
issues. Those are the charges against you. So your motion to suppress that you are about to argue needs to address that particular case, not the others.
You got a copy of that motion for me, please?
You have a copy of my own motion?
I told you we could continue. I go get my copy.
Do we have a motion for compellment today? Oh my God, there goes my day right there. Got a guy rolling into Simpson's courtroom telling him he's on the Illuminati, and then Vaughn shows up. How's a man supposed to get anything done? Yeah, I threw some water on it.
Mr. Vaughn has requested a copy of his motion to suppress.
Logic got evicted. Mirandarization, boy, that ain't a word. Whole jury laughing like, what did we just heard? Unlogical motions, compellment too. He reiterate nonsense like deja vu. Try to squash, not quash his own case in flames. Even spell check filed the motion saying, bruh, that's lame. It's a moot point, baby, sinking in the trial. Sheriff Vaughn freestyle, but it's juvenile. Tried to recruit the judge, the clerk, and his crew. But the only thing recused was his brain from the view. Dixon, Tennessee, home of bad boy blunders. Vaughn taking L's like it's courtroom thunder. Fired his lawyer, then begged for a hand. Elbow counsel stuck like, bro, this ain't the plan. He's pro se, no way, thinking he's slick, but he's playing Uno while the court plays chess quick. Every motion's a joke, every word's a crime. Even Dr. Seuss said, man, that rhyme don't rhyme. Requise, recruise, make up what you choose, but every fake word just adds to your blues. Mirandarize this, moat point that. Sherrick Vaughn rap dictionary looking flat. It's a moat point, baby, sinking in the trial. Sherrick Vaughn freestyle, but it's juvenile. Tried to recruise the judge, the clerk, and his crew, but the only
Right,
thing
on
recused
the
was his
July
brain from the
7th
view.
of 2025, a handwritten motion to dismiss with prejudice / motion to suppression of evidence / motion to quash. Is that the motion you are referring to?
Correct.
I'm not sure that is.
It should have a case number on the top of it.
As case number 22, it's actually,
Yeah, there,
apparently this one is
I think it's,
22-337. That one, the case number on this case was 462, so that does not apply in this case.
the one you're looking for, I think is styled motion to quash / dismiss with prejudice.
And what, motion to quash?
/ dismiss with prejudice. It was filed that July 7th. And I've got 3 pages, but I think online has more pages.
All right, I found it.
There may actually be. Okay.
The motion to quash, dismiss with prejudice, or suppression was in 336. So the only motion that I see relating to this case is the one that you just referred to, filed July the 7th, motion to quash / dismiss with prejudice. Madam Clerk, would you please have, Kenny, can you run a photocopy? Do you have a copy of this motion, General Bryson? Can you run a copy of that for Mr. Vaughn, please? May I see the motions that he filed this morning? Misty, do you mind running photocopies? Make 2, one for Mr. Vaughn and one for Ms. Bryson. You have the, I need the original. Sorry. I forgot we had a color copier. All right, General Bryson, we're going to go ahead and deal with this particular motion to quash or dismiss with prejudice.
Rearrange some things because some of the witnesses that I wasn't going to call at trial are relevant to this motion. So if I could have just a moment, please.
Your Honor, May I make another request to brief my witness, please?
There is no statutory right for you to brief a witness. If the witness is available and you can talk with them, that's fine, but being as the fact that you're in custody, we have certain procedural safeguards that have to be followed. Depending on whether or not we proceed with the trial today, I will determine whether or not you have an opportunity to speak to her.
Shouldn't I be given the same privileges as lawyers?
You will be given the same privileges as a lawyer. And you've had that same privilege to communicate with this witness while you were in custody.
In custody through a monitored telephone conversation and chirps? That's not the privilege I'm required, Your Honor.
You are entitled to the same privileges in court as an attorney would have, but there are certain limitations on that. Because of the fact that you're in custody, you obviously have to be accorded the rights that an attorney would have with those limitations. So
Where are you getting these rules at, Your Honor? Because I would like to read them myself.
we're gonna deal with this motion right now, and then we'll determine whether or not you have any other option regarding speaking with this witness. So you have a motion to quash/dismiss. Is the state ready on this motion?
Yes, Judge.
All right.
State
Mr.
will
Vaughn's, it is Mr. Vaughn's motion, and it is a motion to quash or dismiss with prejudice. So are we treating this as a suppression motion?
Yes, Your Honor. I found this when I was asleep one night. We can treat this as a suppression.
I think reading through the motion, the appropriate legal styling would be a motion to
All right.
suppress.
Then the state may proceed.
State would call Officer Jeffrey Clark.
You can step around, please. Hold.
Are you Officer Jeffrey Clark?
Yes, ma'am.
Do you go by Jeffrey?
I go by Scott.
Okay. But your report says Jeffrey, so Officer Scott Clark. And are you an officer or do I need to use a different title?
Recently promoted to corporal.
Corporal. All right. Corporal Clark, you arrested the defendant on August the 30th of 2022. Is that right?
Yes, ma'am.
Explain to the court where everything happened and what was going on when you arrived.
It occurred at the Exxon gas station at the intersection of Skyline Drive and Highway 46 that adjoins the Crystal's fast food restaurant. The call that we received was a priority 1 dispatch for a disorderly male within the store.
Okay. And when you arrive, had other law enforcement arrived on scene before you?
Correct.
And who was there before you?
At the time, Agent Brad Garland and Agent Ronald Tilley with the 23rd Judicial Drug Task Force.
And
Ronald Tilley, I think so. I believe that's his first name.
Tilley. And had Agents Garland and Tilley already placed the defendant in handcuffs?
Not until I got on scene.
Explain to us where the defendant was when you arrived and what was going on.
When I arrived, they had already moved over to the Advanced Auto Parts parking lot in a Cadillac Escalade.
When you say they, who do you mean?
Mr. Vaughn and Jennifer Dozier.
Okay. And they were in an Escalade. Were they inside the vehicle or outside the vehicle?
I cannot recall.
Okay.
So you're gonna have to speak up. Pull that microphone more. There you go. Speak
There
into
we
the
go.
microphone.
Is that better?
What was your answer? Where were they?
I do not recall if they were in the vehicle or outside the vehicle upon my arrival.
And let's go ahead and cross this bridge. You were wearing a body cam at this time.
Yes, ma'am.
When you filled out your grand jury packet, you requested that the body cam be downloaded and provided to the DA's office.
Yes, ma'am.
And we never got that.
I know the DVD request was submitted. I do not know from my memory from there what happened.
Now, around that time, the agency was also having some problems with the video system.
Yes, ma'am. Files were getting corrupted and the video files were messing up.
Objection,
So-
Honor. She's leading.
Trying to remember what that actual question was. I will rephrase and continue. And did anyone intentionally delete this video?
No,
So we are left with what options on why we don't have a body cam?
I'm not sure how to answer that.
Could it have been human error
Possibly,
or problems with the system?
possibly, yes.
All right, going back to arriving on scene, the parties, the defendant was at the Advanced Auto Parts. Where were the task force agents?
They were there with them.
In the parking lot of Advanced Auto Parts?
Yes, ma'am.
Okay. You said Mr. Vaughn was cuffed after you arrived?
Yes, ma'am. After I arrived, I believe Mr. Vaughn was very hesitant to identify himself at the time after I arrived, and he had the odor of alcoholic beverage coming off his breath in person, and that's when Agent Garland detained him.
What was his behavior like at that point?
I would say irate.
Was he still causing a public disturbance?
Not as much, but being hesitant to cooperate.
Did you question Mr. Vaughn?
I asked him what had occurred at the gas station.
Was that before or after he was in handcuffs?
I believe before.
And did he give you any variation of the events at that point?
He stated to me that they had a disagreement with the female inside the gas station, and that he had held the door shut afterwards for an unknown reason, preventing the clerk from coming out. I know I have in my report, and I believe it was said on scene, that the female inside the store had issues with Miss Dozier.
Was there a search of the Escalade?
There was.
Why was there a search of the Escalade?
Agent Tilley deployed his K9, and I believe it alerted on the vehicle, and there was a search, probable cause search conducted from there.
Was any contraband located in the car?
No, ma'am.
Was anything pertinent to this case located in the car?
There was an ID with Mr. Vaughn's name on it that was used to identify him, where he was hesitant to identify himself.
Did you ultimately decide to arrest the defendant?
Yes, ma'am.
Why did you arrest him instead of cite and release?
With the number of charges that I had at the time, I felt it was more pertinent to make an arrest.
Would you normally cite and release someone for an assault?
No,
Would you normally cite and release someone for a false imprisonment?
no,
Would you normally cite and release someone for a public intox?
no, Your Honor, no.
You said you smelled alcohol on him. Was there anything else in his behavior or demeanor that indicated his level of intoxication?
I'm not sure.
But you didn't do like field sobriety tests or
No,
anything? All right, Judge, I will pass the witness.
Vaughn, you may cross-examine.
That'd be good.
Officer Clark, is it?
Yes, sir.
How you doing today?
I'm doing good. How about you?
I'm doing all right. This case that we're here for on today, do you recall the date of that case?
I believe August 30th of 2022.
2022. So, did you read any reports today, or is your memory just that good?
I'm just referring to my report. from the
Referring
case.
for a report, okay. So just from the report, that's what we're gonna base all these questions off of? You answered them from your report, basically?
Pretty much, yes.
Okay. At the time of this incident that we're referring to, was you present at any of it? Did you see any of it?
No, I did not.
You didn't see any of it. When you arrived at the scene, what was you a witness to?
Testimonies from the victim and talking to you.
What about any other testimonies from Jennifer or the other officers present?
Jennifer was hesitant to say much of what happened.
Okay, what about the other officers?
They just gave me the download of because I was not far behind them.
So
when
you
I
didn't get
responded.
firsthand knowledge of any of this?
I believe, honestly, can't answer to most of that, but I know I was not far behind the agents when I was responding to the call, and they might have told me something, but off the top of my head, I cannot recall.
Okay, so you just have trouble remembering, correct?
It was 3 years ago, so yeah.
Okay, so the time barrier made it troublesome for you to remember what happened?
Sorry.
The time barrier making it troublesome for you
Yes,
to
sir.
remember?
Yes, sir.
Okay. When you arrived at the scene, you said that we were at the auto parts store.
Correct.
Can you recall where me and Miss Jennifer were?
Off the top of my head, I cannot.
How many officers do you recall that was at the scene when you arrived?
When I arrived, it was 2 drug task force agents
Okay.
and myself once I got there.
Let me see here. You said that when you arrived that there was a search, correct?
Later on, yes,
Was you present for this search?
I was.
So you was? Was there a dog at the scene?
There was.
There was. And you said you had a body cam present?
Yes, sir.
Did anybody else have a body cam?
I cannot answer for the drug task force agents because they have their own agency and director and everything. So I can't answer for them. I know when I was present, I had a camera and it was on, yes.
Okay, what about your patrol cam? Was that on too?
Should have been, yes.
And you don't have either of those?
I do not. That was a different recording database brand or whatever you want to call it.
So when you get these recordings, do you submit them?
When we had that software system, those cameras were downloaded daily by plugging them up. The dash cam and car cameras were recorded with an SD card inside the camera. And every pay period, those cards were given to the shift sergeant to be downloaded into the software.
And what happened to them between that time and getting to the courts?
They would be in the software, and then around the time of the grand jury packet, I put a DVD request in for it.
So there was an error somewhere, the reason it didn't make it to the courts?
Possibly.
Okay. Could there have been any errors committed that night that you arrested me?
Are you asking technological wise, or?
Yes.
Very well could be.
Okay. So when we come to cite and release, is that a mandatory or officer's discretion? Is that
It
what
is
you're talking?
discretion.
It's discretion.
Correct.
Okay. Did you you said that you smelled alcohol.
Correct.
Did you give any breathalyzer test?
No.
Did you give any field sobriety test?
No.
Did you have any blood drawn?
No.
And you wasn't present for any disturbance at the Exxon, correct?
No.
So you arrested me without a warrant?
You were placed in my custody and a warrant was drafted and then presented to a magistrate.
At the police station?
Correct.
Okay. So I was arrested, correct?
Correct.
Okay. Without a warrant?
That's how it usually is. A warrant's drafted. You're placed in my custody, a warrant's drafted, and then presented to a magistrate.
Okay. And you stated there was nothing found during the search of the vehicle?
Negative.
But they said a dog did hit on something, so that would be a false positive, or?
I cannot answer to how the workings of a canine are because I'm not certified in that. That would have to be for an officer that has that certification.
Okay, did you see this dog with your own eyes?
I did.
Okay. Okay, so you don't recall me being in handcuffs and sitting on the sidewalk when you arrived?
I cannot recall off the top of my head now.
And then being transported over you and y'all switching handcuffs?
We would have swapped handcuffs at some point, yes, because
Okay.
I do recall Agent Garland detaining you, but I do not recall what you're asking. But I will say, that way I'm not taking that agent's handcuffs. I would have done a cuff swap on you, yes.
Okay, and when I was placed in handcuffs, was I placed in the back of the police car?
You would have been placed in the back of mine.
Okay, and then the investigation continued?
I cannot recall, but more than likely, I probably went and talked to the victim at the gas station.
Okay, why didn't you get any statements that night?
It would have been the recorded statement of the victim and then what she told me.
You didn't think she needed to reduce that to writing?
Didn't think I needed to, no.
Also, I seen in your report that you witnessed you witnessed the store camera of some hands up in the air.
She showed me a still shot from the cameras that she took on her phone.
Did you get a copy of that?
I did not.
You didn't think that was real, reasonable for your investigation to get a copy of that?
It was just my eyes and my testimony.
Judge, we're going into general cross. This has no relevance to the motion.
It has relevance to proving that there was improper procedure, Your Honor, that you put that in your warrant, that you had video camera, then why didn't you get a copy of it?
Judge, if we could have a ruling on the motion.
Motion is sustained. Your objection is sustained.
Okay, let's see. Other questions I got for you. Did you get a statement from Jennifer that night?
Did not.
When you were viewing this camera, was there any other witnesses there?
I believe there was people inside the store, but they were not identified and they did not stick around.
Did you think you need to get their witness statement?
That's up to them if they wanted to stay. I can't forcibly hold them there as a witness. If
Did
they
you
don't wanna
question
come
any
forward.
other witnesses?
I did not.
Okay, thank you, Your Honor.
Redirect by the state.
What did Bethany Page tell you happened inside the store?
Bethany advised to me that Mr. Vaughn was a daily customer and he normally came in there to buy a dip. She advised to me that Mr. Vaughn was irate with her on this day and accused her of being a CI or criminal informant for drug task force and had threatened to beat her up in the store.
Did that cause her to fear that he would actually beat her up?
Yes.
Did other customers come into the store during the time that Mr. Vaughn was saying these things?
I believe Bethany told me there was other customers in there attempting to buy items, yes.
Nothing further, Judge.
Vaughn?
You said Miss Bethany stated that I threatened her, correct?
Yes,
Word for word, can you recall what she said?
not word for word.
Did you inform Miss Bethany her right to get a restraining order?
I did not know.
You didn't? You didn't think someone that was threatened, their life in danger, should be informed that they need a restraining order?
Again, this is outside the scope of the suppression.
Sustained. It has no relevance to
Okay.
the question of whether this motion should be granted.
All right, thank you, Your Honor. That's all I have.
Thank you, sir.
Anything further from this witness? Sustained, I'm sorry. Also, you may step down. Oh, your next witness.
Judge, may I see if my other witness has arrived?
You may.
It would call agent.
Unlogical Logical station, compelment nation, courtroom clown in rotation.
Right, grab a white claw. Settle in today. We got a true legal scholar on the docket, a pro se defendant who's about to teach us all a lesson, though.
Are you Agent Ronald Tilley with the Drug Task Force?
I was
You were. You are now, what is your rank with the police department?
detective.
Detective Tilley, I will do my best to refer to you as detective, but you have been agent to me for a very long time. Now, let's go ahead and clarify. You do not independently remember much about the day when you came out and Mr. Vaughn was at the Exxon.
That's correct.
You've reviewed this report
Yes.
and still have no independent memory.
No.
So what I'd like to talk to you about and to explain to the court is at this time, you were a canine handler, is that right?
Yes.
Okay. Your dog's name was Nina.
Yes.
What certifications did Nina have?
She was certified through the USPCA as a
Aw.
detection dog, odor detection dog.
Okay. What odors was she certified on?
Marijuana, cocaine, heroin, and
I want Nina.
that's
And I'd like to talk about, well, and you two were certified together as handler and dog,
yes.
and you would have had an up-to-date certification at that time.
Yes.
So when Nina or any canine who's certified alerts on a vehicle, does that necessarily mean you're going to find drugs in the vehicle?
No.
Could you explain that?
Yes. So the dogs are trained on the odor of narcotics. So when they detect the odor of a narcotic or drug, they give an alert, a passive alert, such as a sit. And on that alert gives us probable cause to believe that there's narcotics inside the vehicle or box or whatever container type is there. And that's just based off of the odor.
And if a dog is alerting and you're not finding drugs, what does that tell you?
It tells me that drugs have been in the vehicle, whether they were in a case of marijuana smoked in the vehicle or somebody carried them into the vehicle and have left the vehicle with the drugs, the odor still stays around.
And again, do you remember anything about your interactions with the defendant or anyone else that evening?
I do not.
Nothing further, Judge.
Mr. Vaughn, you have any questions for this witness?
Detective Tilley, how you doing today?
Doing good, sir. How are you?
All right. You remember me?
I do.
You do, from the night of the arrest?
Previous interactions, I do not remember this particular night.
I don't think I remember you from any other. I couldn't pick you out in the lineup.
Really?
Yeah, okay. So I know you're having a hard time remembering a lot of this stuff. It's so long ago. You're just based on reports, but I got a few questions for you. When you got the call on your radio, you showed up to this scene. Why did you, as Drug Task Force, show up to this scene?
I believe, I don't remember if I showed up to the call or if I was requested out, but I believe we were just close to the area, so we responded.
Is it normal to intervene with normal misdemeanor calls like that?
Yes, if we're in the area of a call for service, whether it be a misdemeanor, felony, it doesn't matter what the call is. If we're close to it, we'll respond.
Okay. When you arrived, do you recall where you found me at?
I do not.
Maybe auto parts store or Exxon?
The report stated advanced auto.
Okay. Do you recall where I was when you arrived?
I do not. No,
You don't? All right, let's ask some dog questions. Does dogs hit for alcohol?
no. Mine doesn't.
Yours does? Oh, that's good to know. um, do you recall, and how about this? Let's just do this. Instead of me asking you these questions and you don't know, do you recall anything from that night?
I do not know.
Um, um, I just don't see the point in this. You can't remember nothing. Your Honor, that's all the questions I have for him.
Thank you. Any redirect by the state?
The irony of him forgetting what he was thinking in the middle of that.
Task force office, how far is that from that Exxon?
I don't know, 1.5 miles, 2 miles.
So, and my understanding of the questions that Mr. Vaughn asked, even though you're a task force agent, you're a law enforcement officer, correct?
Yes,
So when a call comes out and a task force agent is the closest, even if it's not a drug call, are they going to respond,
yes,
especially for a priority one?
yes.
Nothing further, Judge.
Vaughn, any other questions?
Yes. So you and your partner, I can't recall his name. Y'all would be the first ones on the scene, correct?
I believe that's what's stated in the report.
Okay. Did you make a report?
No,
Why not?
I did not seek any charges in this case. The city showed up and took over the situation.
Would you be a witness?
Yes,
I mean, you first responder, wouldn't you don't think that was necessary?
we don't usually do reports when we're not the primary officer.
You don't do reports, but you think it's okay to show up to scenes? I mean, it seems like you're doing half the job there, sir.
No, the primary officer does the report for just about all calls. Every now and then there will be a supplemental report done for a main report, but usually the primary officer does the report for calls.
Since you brought that up, the primary officer, he wasn't present at the scene when you arrived, was he?
I can't recall if he was or not. I don't believe it was by reading the report.
Okay. So he had to receive all his information from you and your partner, correct?
I guess so.
Okay, thank you, Your Honor.
Anything further? Thank you, Detective. You may step down and you are released.
Thank you, Judge.
State may call us next witness. All right. Mr. Vaughn, the state has rested their proof. Do you wish to have any proof offered on your own?
Yes, Your Honor. I would like to call Jennifer Dozier.
Jennifer Dozier.
Yes, Your Honor.
20 and 10s. A flurry of fallings land with a thud. Got a judicial notice to muddy the mud. The judge looks confused by the arrest of judgment. While our pro se scholar files a motion to squash the whole punishment. The state didn't write back. It's a legal disgrace. And without Mirandaization, he's closing the case. He says, Your Honor, the logic is sound and astute. It all stems directly from a poisonous root. He's serving up his tainted fruit. The fruit, the tainted fruit. From a very illegal poisonous root. This whole damn case you must acquit. Cause it all comes from this tainted shit. The state calls their witness Corporal Javin so calm. Yeah. Tales of the threats and the verbal napalm. I'm a threat for a reason. He said with the glare, then a scholar on cross-exam says hold it right there. To prove that this tree has been poisoned for good, let's play my arrest video. It's misunderstood. Oh, geez, here we go. He's playing the tape. He's literally handing the prosecution the very fruit he wants thrown out. You hate to see it. No, wait, you love to see it. The body cam rolls a spectacular own. The seeds of his legal demise are now sown. Citing Pennsylvania versus Men's with a confident shout while refusing for 8 straight times to even get out. When her jaw gets broke, it's gonna be your fault. He's proven proving the state's case without any halt. He's showing the jury with his own evidence the very fresh fruits of a brand new offense. He's serving up his tainted fruit. The tainted fruit. From a very illegal, poisonous root. This whole damn case you must acquit. 'Cause it all comes from this tainted shit. Then he calls to the stand his one saving grace, his baby mama to plead his whole case. Tell the jury he asks her if you'd be so kind. Am I the retaliating, threatening kind? She swears on the stand he wouldn't hurt a fly, a claim the prosecutor's quick to deny. Now, ma'am, about that aggravated robbery. He thought to praise his character and opened up the door for the jury to hear of the crimes he'd done before. And the jury comes back guilty, unanimous. He showed them the video of the crime, opened the door to his priors, and based his entire defense on a mispronounced legal theory. He served the jury his own tainted fruits on a silver platter. In the end, it was just a fallacy of a mismalice of justice.
You may ask.
Good morning.
Good morning.
You know what case we are here for today?
Exxon, I believe, is what I was told.
Okay, that's just the Exxon case. Was you present at this?
I was in the car.
Okay, you was in the car. Do you recall my state of mind that night?
I mean, we had just left work. That's all I recall.
Okay.
We had just left from Sam's.
You're stupid as usual.
From Sam's, it was our boss.
See how that's gonna work. All right, when the police officers arrived at the scene, where were we at?
We were in Advanced Auto Parts getting a part for Sam's Derby car.
Okay. And what brought our attention to the parking lot?
The police by the vehicle.
What were they doing at the vehicle?
I don't recall.
Okay. Do you recall the doors being open on the vehicle?
I believe at one point they did because they said it was involved with the situation down the road.
Did you see any dogs at the scene
Later,
later on?
Yeah.
Did you see dogs present when?
not initially, no.
Okay, okay. When we exit I'm at the Advanced Auto Parts store. How did the officers address us?
They just approached us and asked what was going on, made us sit on the concrete and figure out what was going on.
Were we placed in handcuffs?
I wasn't. I'm not aware if he was or not. I'm gonna be honest, it's been years.
Okay. Was I irate at any time during this night?
Not to my knowledge, but
Okay. Let's go back over to the Exxon. Was there any police present at the Exxon?
no.
Was there a lot of people present, if you can recall?
It didn't look very packed from what I recall. There wasn't many cars there.
Did you see me threaten anybody?
No,
Did you hear me threaten anybody?
no.
Did you see me cause any incident with anybody at the Exxon?
I didn't see you cause an incident. You know, I heard that, you got into an argument or whatever.
Then
Held
we're
the
gonna
door
have
for a
to
second.
Speak up a little
Sorry.
bit.
I heard that you had gotten into an argument with her and then you kind of like held the door a little bit
Did you see me hold the door?
for like a split second, yes.
Why would I hold the door?
She was trying to get outside, apparently.
What was her actions, the reason I held the door?
Supposedly she wanted to fight me, but I don't even know her.
Okay, where was she at previously before?
Behind the counter?
How did she get to the door?
When she walked around, I didn't see that part. I just looked up and seen you both at the door, and then y'all come out. Both of you come out,
What was she doing at the door?
yelling.
Was she
And just yelling.
scared?
I can't tell you. I don't know how how she reacts when she's scared.
I mean, was she yelling she was scared or angry or?
I mean, she sounded angry to my knowledge, but I don't know. Some people react and get angry when they're scared.
Okay,
You know, I do.
okay. And you don't recall, wait, you said you do recall all that. Did you write a witness statement that night?
No, I'm not talking about it.
Why didn't you?
I didn't ask for one.
Okay. All right, thank you. One more question.
General Bryson, you have questions? Thank you, ma'am. You may step down. You are not free to leave because we have a trial coming up. So you'll step out in the hallway and just remain outside. Mr. Vaughn, you may call your next witness.
Oh, that'd be my last one, Your Honor.
All right. State, have any rebuttal proof on the motion? Mr. Vaughn, I will hear you an argument about your motion.
For first, Your Honor, it seems like nobody can recall the entire incident, my witness nor the state's. The distance of 3 years is making this difficult for anybody other than reading a report, which my witness was not given that opportunity nor briefed. There is no body cam footage to prove anything that none of the officers saying. Bethany Page herself is not here to make a statement, nor does she have a written statement or a video recorded statement to justify what the officer's saying other than each other. There is no proof that any of this has happened, Your Honor. That they followed procedures like they were supposed to. There was supposed to be a warrant before I was arrested. There's no proof that I was drunk. This is a Fourth Amendment violation, Your Honor. Illegal search and seizure. There is no proof that they had any reason to open the truck doors. It just shows malicious intent of the officers, Your Honor, and I believe it'd be in the court's best decision to just dismiss this case. And then it's just in violation of statute 47-103 in grounds of arrest of an officer without a warrant, an officer without a warrant. Arrest a person for a public offense committed in their presence. None of this was even committed in their presence, Your Honor. The arresting officer is coming on hearsay knowledge. The DTF officer showed up, and I'm already at Advanced Auto Parts. I'm not even at Exxon. So I mean, there was no ongoing crime. That's all I have to say, Your Honor.
General Bryson?
Judge, first I'd like to let the court know that Ms. Page is present. She will be testifying at trial. Because a suppression motion is a preliminary question under the rules of evidence, because we are determining the admissibility of evidence, the state may put on hearsay evidence, and that's what the state elected to do under Rule 104, preliminary questions A, questions of admissibility generally. So Ms. Page is here and present. So Judge, first of all, I'm a little bit confused what the defendant is trying to suppress. So you have his statements, which were made after he was asked to take a seat. He did make a statement admitting that he had held the door closed on the witness.
Objection, I didn't, Your Honor.
On scene, Judge, not today.
I would overrule the objection that this is argument rather than testimony by the district attorney, but I would point out that during representing yourself and you asked Ms. Dozier the questions, and when she responded to say that, yes, you had gotten into an argument, you repeated her answers. So technically, the state is able to argue that you have made that statement.
I'm not here to make a testimony, Your Honor. I'm here to defend myself. I was not put under oath.
I understand that.
And Judge, the officers testified, Corporal Clark testified that the defendant told him that he held the door shut. And
The objection's overruled.
yes, Judge. So there was a dog alert on the car. The only thing obtained from the car, which could be argued subject to suppression, is the defendant's identification, which we're not entering into evidence, which would arguably be subject to inevitable discovery. So the only things I can see he's arguing to suppress are his own statements or his identifying documents. So the state is ready to proceed. In regards to the citation in lieu of arrest, the officers observed a continuing offense in their presence, which is public intoxication. And public intoxication, disorderly conduct, those are not offenses that the option to cite in lieu of arrest is available under 40-7-118, which is use of citations in lieu of continued custody or arrest. And if there is a danger of an assault continuing to occur, that is not eligible for citation in lieu of arrest. So, Judge, for the foregoing reasons, whatever he is saying should be suppressed, should not be suppressed, and this case should go to trial.
Anything else, Mr. Vaughn?
Yes, sir, Your Honor. Since the state's confused at what I'm trying to suppress here, Your Honor, let me inform the state that it is illegal against the Tennessee State Constitution and the Fourth Amendment of the United States to arrest someone without probable cause. To detain someone without having any evidence whatsoever, and clearly they still don't have the evidence here to produce today. No body cam footage, no witnesses that can testify that didn't make a statement that the state didn't help them come up with their own testimony here today, Your Honor. Continuing offense, everybody testified. I was at AutoZone when they showed up. So there's no continuing offense for the alcohol, Your Honor. There is no breathalyzer. There is no field sobriety test. There's no blood drawn. There's no proof that I was even drunk, Your Honor. The state can't even prove that. And to place somebody into custody and investigation, I don't even have all the cases here today, Your Honor, but one of them will be Bruton. You can't put somebody in the back of a police car and investigate something. It's illegal. And I was placed in handcuffs and held for a while, Your Honor. Illegal arrest is illegal arrest, Your Honor. I don't care how you look at it. That's all I have for you.
All right, this is a motion to quash or dismiss with prejudice, and the grounds that have been raised has been that it was an illegal seizure under the Fourth Amendment because of the fact that the defendant argues that there is no probable cause for the arrest. The proof that has been offered at this hearing was that law enforcement responded to a report of a disturbance at the Exxon station, which also is involving, I think that's where there's a restaurant there. And as a result of that, when they arrived, the defendant had been moved, or at least when the officer Clark arrived, the defendant had been moved over to the Advanced Auto parking lot. But during the continuing investigation of what occurred, the proof has been, according to the state's proof, that the defendant was irate, that the defendant had a smell of alcohol about him, and that there was a report of there having been an assault and basically a false imprisonment by the holding of the door. The proof also established that the defendant, according to the officer's testimony, admitted that he had held the door, and by the defendant's own witness, it was established that he had gotten into an argument with the clerk in the Exxon station, and that when she attempted to apparently exit the store, that he held the door against her. So the court finds that there was, in fact, probable cause that a crime had been committed at the time the officers took the defendant into custody, and that their response was appropriate, and therefore it was not a violation of the Fourth Amendment because it was a continuing situation that simply had transferred from the Exxon station to the Advanced Auto Parts. So therefore, the motion to quash or dismiss is denied. And the case will proceed to trial. We have other motions that the defendant has filed this morning. In general, I don't think you have had an opportunity to actually read through them. We'll take a short recess, probably about 15 or 20 minutes, and then we'll come back. And since he has put in the case, he has put on these motions the case number of all of his cases, including the 337 that we're trying today. I'd like to go ahead and address any of those motions that we can and resolve all of those issues prior to the trial. The jury is instructed to return at 1 o'clock, so I am intending to start the jury selection process at 1 o'clock, if there is no reason not to. So.
Your Honor, can I brief my witness now?
The only way that you could brief your witness, and the thing is, you cannot tell a witness what to say.
I don't plan to.
When I'm talking, you just wait till I'm finished. When you want to speak to her and ask her the questions that you want to ask her, we can allow her to come into the area where the attorneys would speak to a witness. Mr. Vaughn would be, or to a defendant. Mr. Vaughn will be on one side, and she'll be on the other. If she's willing to talk with you, we'll allow that to happen. We'll stand at recess.
Oh, that was delicious. All right, we're a little behind, so I might be able to skip most of this break. Let me look. Okay, we're up to live now. They should be coming back any second. That was so fun. That was so fun. For those of you who missed it, we had a paranoid crazy guy in front of Judge Simpson this morning. It was really fun. So KDM gets me over there, and I do that, and literally this was starting about the same time, but I didn't know it. So having someone come out and announce that, I mean, I really recommend it when you get a chance to watch that, because he tells Judge Simpson he's a member of the Illuminati. It's pretty damn fun. It really is. Meanwhile, while that was going down, apparently this was starting. We're up to speed now.
Yo, turn the beat up in Vaughn's dictionary. We ain't spelling right tonight. Nah, we spelling wrong. Step in the courtroom. Words all twisted. Sheriff Vaughn speaking like logic got evicted. Mirandarization, boy, that ain't a word. Whole jury laughing like, what did we just heard? Unlogical motions, compellment too. He reiterate nonsense like deja vu. Try to squash, not quash his own case in flames. Even spell check filed the motion saying, bruh, that's lame. It's a moot point, baby, sinking in the trial. Sheriff Vaughn freestyle, but it's juvenile. Tried to recruit the judge, the clerk, and his crew. But the only thing recused was his his brain from the view. Dixon, Tennessee, home of bad boy blunders. Vaughn taking L's like it's courtroom thunder. Fired his lawyer, then begged for a hand. Elbow counsel stuck like, bro, this ain't the plan. He's pro se, no way, thinking he's slick, but he's playing Uno while the court plays chess quick. Every motion's a joke, every word's a crime. Even Dr. Seuss said, man, that rhyme don't rhyme. Requise, recruise, make up what you choose, but every fake word just adds to your blues. Mirandarize this, moat point that. Sherrick Vaughn rap dictionary looking flat. It's a moat point, baby, sinking in the trial. Sherrick Vaughn freestyle, but it's juvenile. Tried to recruise the judge, the clerk, and his crew, but the only thing recused was his brain from the view. Mirandarization, unlogical station, compelmination, courtroom clown in rotation.
Your Honor, I am not a human being. I am the legal representation of my given name. I am the sea, I am a boat, I am the government in God form papers, and the papers are the people, that is not me. Your Honor, as you can see, I do not consent. I do not consent. I do not consent. I do not consent. Your Honor, I am not the person in the video. The evidence is clearly faulty. It was tampered with. The person who you think is me has a different haircut. This is my birth certificate. The person is not me, as you can see. I do not consent. I do not consent. I do not consent. I do not consent. The case law of America says that if the person who represents me is the people who are not the papers. I am the boat, I am the boat, I am the boat. I am the boat. I do not consent. 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 Attention, esteemed viewers. If you are hearing this message, it means that you are sadly witnessing a dark moment in the history of legal discourse. Yes, it's true. Law Talk with Mike is experiencing what we in the business call a plot hole-sized lull. This is, of course, due entirely to Mike's, let's say, ambitious approach to preparation. And by ambitious, I mean utterly devoid. Yes, the very fabric of our legal system, as represented by this live stream, has encountered a, shall we say, temporal anomaly. A glitch, a hiccup, a veritable vacuum of action. And who is to blame? Why none other than our esteemed yet woefully unprepared host, Mike. So sit back, relax. musical interlude is just gonna be a thing. We'll get back to the legal stuff eventually, probably. So to fill the gaping void where insightful legal analysis should be, and due to a lack of any ability to keep your attention, Mike has in his infinite wisdom decided to subject you to this artistic expression. God help us all, please do not hold Mike accountable for this. Bless his heart, Mike didn't quite foresee these moments of dead air when he planned for this whole thing. He clearly has no idea what he's doing, so sit back, relax, and maybe grab a snack. This musical interlude is just gonna be a thing. We'll get back to the legal stuff eventually, probably.
All right, grab a White Claw. Settle in today. We got a true legal scholar on the docket, a pro se defendant who's about to teach us all a lesson, though. Probably not the one he intends. A flurry of filings land with a thud. Got a judicial notice to muddy the mud. The judge looks confused by the arrest of judgment. While our pro se scholar files a motion to squash the whole punishment. The state didn't write back. It's a legal disgrace. And without Mirandaization, he's closing the case. He says, Your Honor, the logic is sound and astute. It all stems directly from a poisonous root. He's serving up his tainted fruit. The fruit, the tainted fruit. From a very illegal poisonous root. This whole damn case you must acquit. Cause it all comes from this tainted shit. The state calls their witness Corporal Javin, so calm. Tales of the threats and the verbal napalm. I'm a threat for a reason. He said with a glare, then a scholar on cross-exam says hold it right there. To prove that this tree has been poisoned for good, let's play my arrest video, it's misunderstood. Oh geez, here we go, he's playing the tape. He's literally handing the prosecution the very fruit he wants thrown out. You hate to see it. No, wait, you love to see it. The body can rolls a spectacular own. The seeds of his legal demise are now sown. Citing Pennsylvania versus Men's with a confident shout, while refusing for 8 straight times to even get out. When her jaw gets broke, it's gonna be your fault. He's proving the state's case without any halt. He's showing the jury with his own evidence the very fresh fruits of a brand new offense. He's serving up his tainted fruit. The tainted fruit. From a very illegal poisonous root. This whole damn case you must acquit. Cause it all comes from this tainted shit. Then he calls to the stand his one saving grace, his baby mama to plead his whole case. Tell the jury he asks her if you be so kind. Am I the retaliating, threatening kind? She swears on the stand he wouldn't hurt a fly, a claim the prosecutor's quick to deny. Now ma'am, about that aggravated robbery. He thought to praise his character and opened up the door for the jury to hear of the crimes he'd done before. And the jury comes back guilty, unanimous. He showed them the video of the crime, opened the door to his priors, and based his entire defense on a mispronounced legal theory. He served the jury his own tainted fruits on a silver platter. In the end, it was just a fallacy of a mismalice of justice.
Pretrial. is crazy. Ma'am, are you a whore? You're not a whore? Not a whore? You're not a whore? I never want to hear it again. Sweet Jesus. You're not a whore? Not a whore? You're not a whore? I never want to hear it again. It gets worse.
There were drugs involved that were given to me that ended up being glue. Like I smoked some glue and stuff. I thought I was smoking crack.
Let's go.
You didn't say the cat jumped on his wiener, did you? Sit down and shut up. Shut up. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up.
All right, we are ready to start to take up these other motions if they relate to the case that we're on trial for today.
Okay, back to the
First one I have is a motion to reconsider, and that is Mr. Vaughn's motion asking for access to videos that are material evidence as he plans to prove due process violations and evidence required to file a proper complaint to the higher-ups, such as judicial conduct, board of professional responsibilities, risk management, and the appellant courts. And he's requesting under freedom of information. You want to address that issue first, Mr. Vaughn?
Yes, last time you stated that there was.
Mr. Vaughn, come to the podium, please.
There's numerous reasons why I'm requesting that information, these videos. Last time you stated that it was public knowledge, well, and for the fact that it may be.
And
public
all of them are
knowledge,
stupid.
and I'm incarcerated and there's material evidence of due process violations and things that are, let's say that, like for instance, I requested for entirety of the things that were filed into my case. I feel like there's things missing. Like for one, your orders in this court ain't even in there. There's nothing in there for me, not one order that you, except for an order for the witnesses. And with it being part of the public Freedom of Information Act, it should be given to me, Your Honor. Yeah, and with the situation that I'm in, I mean, if it was public knowledge, I should be able to go get it. But being in the situation I'm in, I shouldn't be denied it just because of the situation I'm in. And that's my argument, Your Honor.
State have any response? Vaughn, I have previously ruled that those YouTube videos that you're asking to be downloaded onto some sort of a device that you could then review them, those YouTube videos are not evidence that can be used against you in court. And as a result, our appellate courts all operate from a written record, a transcript of the proceedings rather than any sort of video. They don't watch videos of cases that go up on appeal. Therefore, we are a public court, and those transmission or the publication of those videos has no other purpose other than to comply with the open courts policy that the Supreme Court has adopted. Therefore, they are not under the control and dominion of the state, and the rule is that under the rules of 16 for discovery and inspection that you're entitled to, that it provides that you're entitled to inspect and review any documents, photographs, tangible objects, including videos that are within the state's possession. These are not within the state's possession or custody or in control. And for that reason, you would not have the right to request those items to be provided to you. And as has previously been stated, they are public and can be viewed by you if you choose to do so or have someone else on your behalf do it. But as far as this court ordering that those have to be somehow transmitted or transferred onto a document or an item that you can then review and have in your possession, I'm denying that request. The next motion is requesting a sanction.
Excuse me, Your Honor. Who has access to them then?
Pardon?
Who has access to them? I mean, you have a camera right here.
The whole world has access to them.
You said, like,
all they have to do is go to YouTube and watch it.
I mean, I'm trying to receive access because, I mean, it is video evidence that I can prove my case. Without that, I can't prove my case.
Why?
Because the things happen on video and it's not even on audio. The same way I found out about things that happen on video, the due process happened on video. And then you said that the appellate court doesn't view video. I've read plenty of cases where they view videos, Your Honor.
I have no evidence before me that there is anything that would be shown on a YouTube that's not also shown on the transcript of the proceeding that would affect your ability to guarantee that you have proper due process. So I have denied your motion.
All right. I believe you're just trying to conceal.
I'm sorry.
I believe you're trying to conceal injustice, Your Honor, doing that.
Yeah, I am trying to conceal injustice.
Yes, you are.
Well, you're entitled to your opinion, Mr. Vaughn, but I am ruling on what I think the law is correctly stated.
And you clearly just stated video. Now you're saying no video?
Conceal
Those videos
injustice.
are online. I'm not going to argue with you about this. I have made a ruling, and that ruling will stand. So you can go on to your next motion.
This requires a fez bonnet.
I reserve that for appeal.
Pardon?
I reserve that for appeal.
What, the motion for sanction?
Yes, I do.
All right, show that he has reserved it for appeal. He is not going to argue it. The next motion is the motion to deny the state's witnesses.
Which one? You didn't. Which one did you just put for appeal? The motion to reconsider?
You said motion requesting sanctions. You said you were saving that for appeal.
No, I want this one for appeal, the first one, Your Honor.
You have the right to appeal any motion that I've ruled upon. So I'm moving now to the motion requesting sanctions.
Okay, yes, let's go that one.
Your motion, argue it.
Our last court date, you stated that you was going to have the clerk, Ms. Pam, here inform the jails that to view my discovery. When I got back to the jail, I had no chance to view discovery, and the captain himself stated that I need to write him a request, and he'll approve whether I receive discovery or not, and that's clearly an disregard to your order that you gave out of this court. I'm requesting a sanction against him for contempt of court, Your Honor. I mean, he was handed down the order and he did not follow it.
And your argument is that you're arguing that solely because he just stated that you had to ask permission and the jailer would have to approve it, that becomes contempt of court?
That and the fact that I never got the chance to view my videos. And another thing, he's telling me to request something when he knew that somebody tore the pole down a couple of days ago, and there was no way to even use a box that don't even work in your pod. So I can't request something. I shouldn't have to request something when the judge said to do something. If the judge tell you not to do something, you don't do it. If the judge tell you to do it, you do it. It's just simple as that. You shouldn't be able to make up your own rules outside what the judge says. So he's hindering the defense from preparing for court.
All right. Let me hear from the state on that particular issue.
Judge, if I may clarify, as far as it pertains to this case today, there are no videos. The discovery is all paper. Does the defendant have access to his paper discovery? Or are we only talking about videos?
Your Honor, my paper discovery was confiscated from some time, and then turn around. I have all cases, not just this one. So let's not just single out one case.
I'm only dealing with this case today.
Okay. There is no. Well, I got my paper discovery back, but it was confiscated from me.
All right. Well, the fact that you've been provided with a discovery for this case means that, in this court's opinion, the jail has complied with the order that you be provided with a discovery, and therefore any other motion regarding sanctions on the other cases involved would have to be heard at a different time, since we're moving forward to try to get to our jury selection at 1 o'clock.
Well, the question I had, will you place another order in, then since the first one wasn't complied and we're putting this off because I'm going back and I'm still not going to have access to it without your order?
I've already got a standing order that you be provided with discovery when you receive it. There's an order down. You've told me that in this case, the one I'm dealing with today, you have received the written discovery, which is all of the discovery that you would have entitlement to, and therefore there is no contempt as to this particular situation. I have a standing order that he's being allowed to have the discovery provided to him. There's only one remaining case after today. Is that correct, General? No, we have to retry the driving on a revoked license.
That, and I want to prepare for,
Let me ask, I'm asking her a question.
Judge, the state's going to make a decision on the other cases at the end of today's trial.
I still need to prepare for appellate court, Your Honor, and then with the fact that this is a fast and speedy trial motion still, that we're still under fast and speedy trial, not to hear this motion today and get something going on that will start that process up and cause me to request for a continuance.
We have tried 2 of your trials, and we're going to try the 3rd one today on 3 of your different cases. So that will constitute 3 of those. The state just advised me that at the close of business today, they will determine whether or not they want to proceed on the 4th and 5th trials in your cases. And then if, in fact, they decide they want to proceed, then my order will be that you have access to the discovery materials on those cases that are still yet to be tried.
Okay.
Your next motion is the motion to deny state's witnesses.
Okay. The motion to deny state's witnesses. The state sent me I don't have a copy of it. The state sent me a copy of their witnesses. A few days ago, I received it. The problem with this is that this case is all the way from 2022, and I didn't know the state had witnesses. Even when I looked at the grand jury list, there was only an officer name. Now, a few days before trial, these witnesses pop up, and that the witnesses should have been given notice at arraignment or 10 to 15 days after arraignment. And that's pursuant to Rule 16 and General Assembly Rule SB 1336. I should have been provided that is not at the state's discretion. If they filed it into the court's records, then they should have gave defense notice that who their witnesses was. So to dismiss the state's witnesses, because I haven't even had a chance really to figure out if they had any background checks done or anything. Anything going on with this, Your Honor? Do they have criminal records? Was the defense given the adequate amount of time to prepare a defense for these witnesses? No, the answer is no to all that, Your Honor. That's my argument.
State's response?
Judge, the defendant incorrectly cites the law in his motion. The criminal rules procedure, Rule 16, do not specify a 15-day time limit. What he's referring to with Tennessee's General Assembly Bill SB 1336 was proposed legislation in 2013 that never became law. I was able to find that. So while it does exist on the internet, it does not exist in the codified Tennessee Code. The state has provided open file discovery to the defendant. The state has provided discovery to previous attorneys. All witnesses being called today are mentioned by name in the discovery previously supplied to the defendant.
Rebuttal. She says that it was open file. I have no access to them open files. She says that she also have given them all previous attorneys. My first attorney, we was rescheduled twice for her failure to even get discovery and the state's failure to give it to her. The second witness, attorney Mike Flanagan, never showed me any discovery, and I've proven in this court with text messages of insufficient counsel from him. My third assistant counsel, Lee Spratt, I proved in this court also that he didn't bring me discovery. I mean, it's consistently the same thing over and over again. So, I mean, when she says that I had proper notice, there is no proper notice except a week before court. And open file, I mean, I've had issues with the court clerk too. I mean, I'm not getting nothing I really needed. That's my argument.
All right, well, Rule 16, subsection 1F, A1F, which is what is cited in the defendant's motion, provides that upon a defendant's request, the state shall permit the defendant to inspect, copy, photograph books, papers, documents, photographs, tangible objects, buildings, or places or copies or portions thereof if the item is within the state's possession, custody, or control, and the item is material to preparing a defense. The government intends to use the item in case in chief in trial, or the item was obtained from or belongs to the defendant. Nothing in that indicates that the names and identity of the state's witnesses are required to be compelled. The state is compelled to give that information. It is routinely provided, and again, outside of the rule of discovery that the criminal procedure rules provide. And this court finds that the state has provided the information regarding those witnesses to the defense in numerous trials, in numerous instances, with the discovery on all of these cases, and that therefore the state has complied with the rules of discovery. Mr. Vaughn, you have been given the opportunity to have numerous attorneys. You've been given an opportunity over and over again to have an attorney represent you on these trials, and you have indicated that you wanted to waive your right to have an attorney, and therefore the court has to conclude that the state has complied with the discovery request, has provided you with all of the information you've requested, that they are required to under the rules, and therefore your motion to deny the state's witnesses is denied.
I do have one question, Your Honor. When did the state provide me with all this in discovery? It wasn't in discovery.
Well, you say that, she says that it has been. I have no evidence to indicate that it was not provided.
You can look in the file you provided for me when I requested. It's not in there.
The file that was provided to you was a copy of the court's record. The state's discovery is not always, never included in the court's file. So therefore, the record that was provided to you would not have that information in it.
Would there be a proof of service, Your Honor?
All right, motion to request all orders of the court.
So there wouldn't be a proof of service, Your Honor?
Pardon?
There wouldn't be a proof of service?
A proof of service on what?
That she provided me with that information?
That I provided you with that information?
I said she.
That she? The state has indicated that they have done it. I don't know if there's a proof of service or not.
But they can't provide that, so that means it's false, Your Honor. They don't have no evidence of that.
Well, General Bryson has indicated that they have provided that information to your prior attorneys and has provided that information to you. You acknowledge that you received the names and addresses, the names and identities of those witnesses within the before trial, even though the rule doesn't require that that be permitted, and they have provided that to you. So your motion to deny the state's witnesses is respectfully denied.
Okay.
We'll move now to your motion to request all orders of the court.
Yes, Your Honor. It goes back to where I requested from the time of preliminary hearing to present date. There was no orders in there, and I believe it's in your well right to make orders of the court verbally, and I'm requesting that you put those in writing so that I can review them and prepare my appeal. I'm really respectfully asking the courts to do that because I got so many things I'm trying to appeal, and y'all hit me with all at once. I got 30 days to appeal all of it at once. I mean, that's kind of harsh and cruel. So
not harsh and cruel. You filed a motion for speedy trial, and we're trying to give you, in all of your cases, and we're trying to give you what you asked for, a speedy trial.
Yeah, a speedy trial, but then give me the paperwork I asked for too, then, Your Honor.
Well, we're giving you a speedy trial. The orders of the court are reflected in the dockets, the rule docket that is prepared by the clerk. And if there is a specific order that has to be requested, then before you have any sort of an appeal, that order will be entered and it will be a part of the record.
Well, here's my official request, all of them.
Is there an order regarding 337 that's on trial for today that you are wishing to address?
No, Your Honor, and respectfully, I mean, there is more than just that case. This pertains to all of it. We should just probably have a hearing date if you just don't want to hear all of it today, Your Honor.
Well, I'm hearing anything that relates to 337 today.
So we're just gonna trump the rest of them?
We're not doing what?
We're gonna just disregard the rest of them?
I'm not disregarding the rest of them. I'm simply telling you that we're hearing the 337 motions today, and then we will, if there's anything else that has to be addressed, we'll do that. The other two cases that you have that are yet to be tried are going to have to be a decision made about a state as to whether or not they wish to try those cases. But right now, I'm only, that one of those is the driving on revoked license that you withdrew your guilty plea on. The other case is going to be, what, I don't even know what the other case is. That one is the aggravated assault while displaying a weapon, reckless endangerment, and so forth. General, is that the one that's remaining after this one? So that's docket number 462. And we will set a hearing date before 462 because I cannot give you another trial date on your speedy trial motion until probably January at the earliest. So what I'm telling you, I'm not disregarding your motions as to those, on those orders regarding these other cases, but I am simply telling you that we have dealt with 337, and now we're moving on to your next motion, which is a motion to reconsider.
Okay, yeah, I'm requesting that the court's motion to reconsider, that the courts previously granted me the right to have a bill of particular in these cases, and then it was just left floating out there. Nothing ever came of it. You spoke on it 2 to 3 times in this courts, and you granted it. You made a ruling on it, said that you granted it, and it was never provided for me. That'd be one of my arguments. And then I'm going to ask you to reconsider the evidence in chief for the cases. You stated that it was a part of discovery, and as you read Rule 16, it doesn't state that it's part of discovery. It states that on the defendant's motion that it should be provided to them. And I've placed motions in and requested letters to the DA, and I've openly in this court requested them multiple times, and you denied that one particularly. And to be honest with you, if I had these evidence, I believe that I could be well more prepared for court than I am, Your Honor.
You know when you filed your motion for bill of particulars?
I'm gonna say that was back of last year, around May. And you granted it that date, and I came back, you granted it a second time. maybe February, May. Yeah, it was had to be May.
Of this year?
Last year. That's another reason I requested video footage, Your Honor.
It is. You better have a damn good reason, though. Otherwise, it just comes off as, I didn't like your first ruling, which is what it usually is, and is denied.
That's not the argument here, Your Honor.
Let her finish.
The argument.
Yeah, the asking for legal advice is not the argument, Your Honor. I've filed it. I've clearly referenced it twice. For it to be missing out of there that's out of my control, Your Honor. I'm clearly showing multiple times I made the intent to prove that I done what I said I done. There's evidence that I even filed it. I mean, if the original motion ain't in there, I don't know what to tell you, Your Honor.
I'm going to make a motion for conjugation camp instanter just to get through the rest of the hearing. He needs some grammar
There
nuns
is a March
standing next to him.
2024 motion that says request, motion of discovery / bill of particulars. It then contains the following paragraph. The foregoing is true to the best of my knowledge, understating in good faith and my belief, this is a request to the record for a bill of particulars and a motion of discovery. Notice to the agent is notice to the principal. Notice to the principal is notice to the agent. Sharik Marquis Vaughn, within by my own hand, without prejudice, all rights reserved. I can't respond to that, Your Honor. It's not a specific request.
Your Honor, asking the state respond to that, I mean, on that date that we speak of, she didn't bring that argument up. For me to bring it up now and not give me time for rebuttal or to address my errors in my motion would be unfair, Your Honor. I can see my own errors. I don't need no advice from her. At the end of the day, you granted those motions in these courtrooms, Your Honor. And you did not deny them, so I should be entitled to
Docket
them.
doesn't reflect that that motion was heard and granted.
If the things was putting down in writing, Your Honor, then we wouldn't be having this argument.
We wouldn't be having this argument if the court the court speaks from its rule docket. And as a
was
result
put
of
down
that,
in writing.
I don't find that there was actually a hearing on your motion for, if you deem it that, a request for a bill of particulars.
Transcript will show it, Your Honor.
What?
Transcript can show it. We can move to the next motion.
I show that on May the 16th was the first time that we had actually had a hearing on those motions that would have been filed in March. And there was a pro se motion for request for a criminal record, which would be provided in discovery. pro se motion to remove counsel, which was denied by me, a pro se motion to demand a speedy trial, and that was the reason that we're proceeding today. Pro se motion for discovery. I ruled that you would receive all written form and copies of anything that you were entitled to. Pro se motion for recusal of the master clerk. It would be no basis, I denied it. Pro se motion for recusal, removal of the court reporter. I found there was no basis for that and denied it. And a pro se motion requesting copies of the records in file. That one was not addressed, but I think it was subsequently provided you with a copy of all of the court file.
Yeah, a year later. There's multiple other motions I noticed that when I was looking at that I didn't see show up, Your Honor. So, I mean, that isn't proof here today.
Well, I don't find that there is anything in the record, but I'm going to step off just for a minute to look at the rule on this motion, and then I will come back. We'll take a short recess.
Judge Simpson will tell you that being a no, we just have one question: are you a hoe? Mrs. Shots, oh Mrs. Shots, oh where did you go? We have questions like on the weekends, do you work selling burritos? The law talk with my crew, we're here to laugh at you. We see you in court acting all tough. You solve issues and life must be so rough. Without getting into further details, there were drugs involved. I thought I was smoking crack, but it was just glue that dissolved. Oh man, I gotta get it together, because wow, that was messed up. And your honor, I have IBS, and I'm bleeding inside, and it's really been rough. The law talk with my crew, we're here to laugh at you. We see you in court acting all tough. Your soul says sins and life must be so rough. And now Kinky Kelly is shacked up in bed with the fruit bowl. Then the cat jumped on his wiener and started causing trouble. Love exciting and new, we are and always will be. The law talk with my crew. The law talk with my crew. We see you in court acting all tough. Your soul says sins and life must be so rough. Without getting into further details, there were drugs involved. I thought I was smoking crack, but it was just glue that dissolved. Oh man, I gotta get it together, because wow, that was messed up. And your honor, I have IBS, and I'm bleeding inside, and it's really been rough. The law talk with my crew, we're here to laugh at you. We see you in court acting all tough. Judge Simpson will
You know me, the great Blandino. Go ahead and zap me, it'll never flap me. Give me 5 seconds on a stun cuff happily. Just don't you dare go and lock that courtroom door on me. Don't lock me out. And then the water is all over the table. Yeah, that table brought to the wrong table. Of course, it's getting on my papers. Judge, it's wetting all my stuff. And the entire judicial process grinds to a halt for a spill. The court goes into recess to find a remedy. A voice calls out, order! We're back in session, we got paper towels. And we found some dish towels too. Dish towels. Let me tell you about a judge down in Maryland, state judge. He had a fellow pro se, dreadlocks and a suit showing respect, but he just wouldn't stop talking. So the judge on the bench told the bailiff, push it, push it. And the bailiff pushed a button and this guy got zapped right there for talking too much. And I would rather have that done to me, honestly. You know me, the great Blandino. Go ahead and zap me, it'll never flap me. Give me 5 seconds on a stun cup happily. Just don't you dare go and lock that courtroom door on me. Don't lock me out.
You are here in the small claims division of 3B District Court. The rules are relaxed, they are not as strict as they are in the general division of the court. We don't strictly follow the rules of evidence or procedure. Neither party is allowed to have an attorney in small claims court. Raise your right hand. Do you all swear or affirm that any testimony you are about to give in this matter will be true, to the best of your knowledge and belief? There is no formal record in small claims court, and there is no appeal. Any decision made here is final. Either party has the right to remove the matter from the small claims division to the regular division of the court, where you can sue for up to $25,000. But you would have to tell me before we begin. Once we begin here, any decision made here is final. Raise your right hand. Do you all swear or affirm that any testimony you are about to give in this matter will be true, to the best of your knowledge and belief? To the best of your knowledge and belief. To the best of your knowledge and belief.
All right, we're back on the record. I have considered your motion for bill of particulars. I do not find that there was ever a ruling made on that motion, or that you brought that motion to the attention of the court to argue the motion, that you've never argued the motion. There's nothing in the record that reflects that. I know you say that you did. But Rule 7 of the rules of criminal procedure, Rule 7C provides that on the defendant's motion, the court may direct the district attorney general to file a bill of particulars so as to adequately identify the offense charged. And it is not an automatic right, and it is not to be used as a means of discovery. Case law is very clear that a bill of particulars is not used for the purpose of a broad discovery request, and it is means only of learning what, or more precisely identifying the offense charge. In this particular case, docket number 337 that we're dealing with today, the offenses are assault, which is set forth in defined simple assault as defined under the law, in that the defendant is alleged to have knowingly caused Bethany Page to reasonably fear imminent bodily injury on the date of August 30th, 2022, that he's charged with false imprisonment on count 2, and it alleges that he unlawfully removed or confined Bethany Page so as to interfere substantially with her liberty on the date of August 30th, 2022, that on count 3, that he was guilty of a disorderly conduct, and that he then and there on that date in a public place with intent to cause public annoyance or alarm unlawfully caused a disturbance, being loud and disruptive, engaged in fighting or violent or threatening behavior, and so forth. And count 4 was public intoxication. The court finds that those offenses are adequately identified in the language of the statute as quoted under the indictment, and that a bill of particulars is not necessary to identify the offenses charged. So therefore, the court is of the opinion that a motion for bill of particulars would not be granted and therefore your motion to reconsider is also denied.
What about the other part of the motion, Your Honor? What about the other part of your motion? Motion, Your Honor.
What other part?
I said, and a motion for chief evidence in chief, chief evidence. You made a ruling on that in this court, that you said it was a part
I'm
of
sorry,
discovery.
repeat that, a motion what?
Chief evidence, I didn't word it right in here, but it's the evidence in chief that the state plans to intend to use at trial, Your Honor. And you made a ruling in this court that it was part of discovery, and the rule states nothing of the such. It's not part of discovery. It says upon the defendant's request that it should be provided. And I made that request in this court, and it's not been provided, Your Honor.
You have been provided with all of the evidence relating to 337 according to the state, all of the evidence that they intend to use. You have a sub-paragraph that states, I have wrote a motion for a bill of particulars and a motion for chief evidence, which the state plans to use in each case. Says the court granted the motion for the bill of particulars and denied the request for the state's evidence in chief they intended to use at trial. I mean, basically, you are entitled to discover the evidence that Rule 16 of the Rules of Criminal Procedure allow you to discover, and that evidence has been provided to you according to the state, and they have provided with you all of that information. So therefore, I have denied your motion to reconsider based on the fact that, in my opinion, all of that has been addressed.
Can you reread that rule, Your Honor?
I don't need to reread the rule, Mr. Vaughn. I have made a ruling.
Okay, I reserve that for appeal too.
Oh, that's fine. Is there, I think that concludes all of these motions.
No, sir.
And we are.
No, sir, you have two more motions in front of you, should.
What are they?
Hold on, you got another motion to reconsider and a motion requesting criminal history.
Well, you had a motion to reconsider your request to be provided with YouTube videos, and I've already ruled on that motion to reconsider.
And there's another one for a transcript. I mean, I'm sorry, not reconsider, a motion for review.
Motion for review?
Yes, sir.
And when was it filed?
It filed today. It's with the rest of them.
All right, I have a motion for review. Let me. So you're asking for a deadline for a transcript to be completed in regards to this. This is what transcript that you're actually. What is it that you're asking the court to do in this motion for review?
You granted the transcript from preliminary to present date on all of the cases that we have heard in this court, Your Honor, and also anything that was said for the record. But you have not placed a date on that. And every time I bring it up, I keep hearing everything but a date that is getting done, it's getting done, it's getting done. Like, and I'm requesting that you place a deadline on it, Your Honor, so that I'm not just left out there floating, wondering when it's ever going to get done, Your Honor.
All right, and you're talking about a transcript of each of your court appearances?
And that, the motion to suppress, even the last trial, Your Honor. I mean, it can be provided to me in parts if need be. If it's kind of, I understand it's a kind of large request, but not to put a deadline on this, Your Honor, just. It's almost a month since the last time we spoke about it.
Well, understand that your request for transcripts has been granted provisionally because of the fact that I'm trying to allow you to have access to that. But if you're needing it for the appellate record, sentencing hearing in these cases is set for January. What date in January?
It's not just for appellate alone, Your Honor. I would like to prepare some motions for this court to hear too before I file for appellate appeal.
All right. We will show that the transcripts, Ms. Billingsley, to the best of your ability, if you can complete any transcripts that he's requested by the January 25th date or before, if possible. If not, if you would just let us know so that we can determine what the status is. All right.
Your Honor, can I get it a little before? Because I
Pardon?
would like to put in a motion for new trial, and I would like to have that in before. Is that, I'm pretty sure that's how the rule reads.
Your motion for new trial would be due to be filed within 30 days of the entry of the sentence in your case.
Okay, that's fine. Thank you.
All right. The last motion is a motion to request a criminal history.
Oh, I forgot I was arguing. Requesting for criminal history, Your Honor. I believe the state just previously, a few minutes ago, even mentioned that that's not the first time I put this motion in. You never made a ruling on it, and it would be a part of discovery, I would say so myself, and a part of my defense. I mean, I could adequately try to impeach witnesses with the proper evidence if there was any provided. I mean, if there wasn't, I wouldn't informed of either way, Your Honor. That's my argument.
State have a response?
Judge, the state does not have in its possession the items that are being requested. The state can advise Mr. Vaughn that Ms. Page has no felony convictions and no convictions for crimes of dishonesty, which would be the only things that he would be able to ask her about in front of the jury.
All right. Under Rule 16, again, the only thing that the state is compelled to provide to a defendant are those information, articles, documents, and so forth that is within the possession and control of the state. And they don't have any such information regarding these witnesses other than what you've been advised as to Ms. Page. The fact that Ms. Page does not have a felony conviction or a conviction involving moral turpitude, those would be the only two bases upon which a person could be cross-examined about prior criminal convictions. That answers your question. The court does not have any, or the state is alleging they have no information about Tammy Vaughn. If you cross-examine those individuals, you have a right to ask the question, but the question is limited to, do you have any felony convictions? Have you ever been convicted of a felony crime or a crime of dishonesty? Those would be the only two bases for cross-examining a witness.
Your Honor, would you clarify what is a crime of dishonesty?
I don't have to qualify that for
No,
you. I don't have to define it for you. You're representing yourself. If you had a lawyer,
Yeah, I'm asking
your
you for
lawyer would be
clarity.
able, just when I'm talking,
Okay.
stop talking. When you had a
Yeah.
lawyer, you would have the opportunity
Right.
to have a lawyer exercise your, on your behalf, and you've elected to do that. As I've explained, the rules apply to you the same as
keep
it would
going
be a
over that. I don't
lawyer.
need to hear that no
I would
more.
not explain to a lawyer what crime of dishonesty was, and I will not explain it to you. That is the rule. All right, that concludes all of our motions that we're hearing. We will resume with the jury selection process at 1 o'clock. We stand in recess until that time.
Love it. Ah, that ended strong. Where are we here? That's 10 minutes from now. We'll just hang out and listen to tunes till then.
Up before the dawn, the town's still half asleep. Young Jeff Middleton on the truck, trash pile deep. Count the coins in his pocket, dreaming bigger than the day, wishing he could clean up the town in his own judicial way. He wiped the grime off his brow, took a long hard look, thought about the simple life, the one outside the book. Then a grin cracked through the heat. The truth came clear enough. All I need's Italian sausage and a corn dog. That'll fix me right up. Remember Judge Middleton said all you need's an Italian sausage and a corn dog. When life's got you down and the road's a mess, that'll fix you right up. No more, no less. A young man in a buggy sitting down in court, Tried out the big world, but his joyride fell short. Judge leans forward and says, wait just a minute, son. I know all about rum spring and I've seen where the road runs. You've been pushing your limits, testing every curve and bend. But if you keep that pedal down, the road will get you in the end. Middleton smiles wide. There's a good advice land. All you need's Italian sausage and a corn dog. That'll fix you right up. Remember Judge Middleton said all you need.
Okay, do we have an hour and 10 minutes? Then I'll close it and do a new stream.
When life's got you down and the road's a mess, that'll fix you right up. No more, no less. Here comes a man, paper stacked up high, spouting soft city lingo, thinking he's sly. I need proof of jurisdiction. He argues and screams. Middleton
I don't use anything.
back. YouTube gets it seen.
Viewers send them to me.
Grin, he shuts the whole thing down. I won't entertain that Jabberwocky clown. Then he lands the truth that makes the courtroom erupt all he needs.
Okay, so here's the deal. I don't know. With the exception of Pretrial from Kelly, I think all of these are basically made by feeding transcripts of the streams to AI. I could be wrong, but that's what I think the process is. But I'm not the one doing it. The reason why I say that is the lyrics contain not only contents of the hearing, but my comments in there. I'm not telling anybody how to do anything. They just send me a song. And then I laugh and play it for you guys. Like this. Because who doesn't love a song with 27 euphemisms for blowjob? Beautiful.
In the tabloids, watch the fire spread fast. Two little lies in a cradle of glass. You painted halos on shadows, wrote lullabies for ghosts, but the elaborate scheme was conceived in your
if I can find all the people who sent them to me, maybe I can work something out and do a list.
Silver screen line in a magazine dream.
A lot of it's killer hip hop. This is Bob Meyer.
Whispers made flesh, your tonsil twins, yeah, baby bump in a pillow with it, play it, pretend till the truth walked in. The spotlight fades and the lights grow dim. Now who's gonna hold your tonsil twins? Your script was a mouthful, too hard to conceal. You spat out your lines, but choked on the reveal. The truth was a burden you couldn't swallow low down, and the stain of your tail splashed on your gown. It's hard to keep your story straight when the paper trail shows no due date. You said they were real, but they're born in your spin. Echoes and rumors, your tonsil twins. You danced on the edge just to reel them in. Your whole defense started to spin. Now all that remains is a stain on your chin. Nobody's buying your tonsil twins. Detectives knocked on the door one more, woke you up where the lie was born. Your load of lies, now a sticky mess. Every word you spoke is a stain to dress. You said they were real, but they're born in spin. The verdict comes down, you'll never win. Thirsty for fame and TV shows, you got left drinking from an empty hose. Now the truth's been shown. twist. You're all alone with your tonsil twist.
Okay, looks like we got another hour. No, we're not doing tonsil twins again here. Looks like we have another hour, so I'm going to close this stream down and do a fresh one for the trial. Good Lord. I will see you all in a little bit.